Hello, this is Antonio Mugali. This particular tutorial, I want to touch on the other two cases regarding the state case. This case originated out of, so it was August 6th, 99.
A brief background of
Yes,
the event.
there was a lot going on. The arbitration case with Penson and Empire was going on. Issues. And then we discovered more legal issues in the union case, and then if the court had to remedy it regarding that. So I was debating that. So I was in the process of obtaining the patent on a projectile, so I was in the midst of this patent.
Yeah.
And I was debating if I was going to manufacture it and distribute it,
Yeah.
and all the licensing or whatever. Was also the issue I was possibly gonna
Bullet.
right if I was just gonna try to get royalties from it and license it. With all the licensing of this particular would have been close to 10 grand.
Yeah.
Okay. United States First Miller, it explains the intent and the purpose of the Second Amendment. So if I have a federally protected right for ammunition, guns and ammunition,
Yeah.
well, then why would I have to pay a $10,000 fee? It's a prior restraint that's licensing. So there was the issue that the Second Amendment was actually applied, that it implied the general obligation of all of adult males to be the primary enforcer of the laws. So that leads into a much bigger legal issue as if it's being applied and interpreted in that fashion. And I needed to know what direction and where that right or the Second Amendment fell for how I would structure the company or the business of what I was going to do. I was in the midst of writing the book, and then I was discovering, like I had discovered the declarations were false, and I knew that the
Declarations in the
Union
cheese case
was false.
were falsified.
And the expert witness was. So then I didn't know
So
how
you're
that
going-
was going to play out.
So you're going through all these cases. waiting for all
Right. So
these
I'm
cases.
debating, how am I going to proceed? How long is it going to take? If I start challenging union, is it going to affect my other case? They're going to,
Oh, your patent.
Right.
your
So
licensing.
and they were withholding the patent. I think I'd paid the fees, and there was failure to issue that patent. So there was just, remember. And then do I finish off the book and put information in there, or do I just hold off until litigation?
So your point is you had a lot of issues.
Right, and then we haven't gotten into
going
the
on.
intellectual property, so I couldn't sleep. Okay, so, you kind of understand what was going on. So actually, I'm actually heading out, and I run into Donnie at the top of the steps,
This is on August 6th,
August 6th, around 4 in the morning.
4 a.m. All right.
So I go for the ride, and I go to Dover Park. Well, I'm heading toward I usually went toward Dover Park, like that side of town.
So at how many miles do you think you'd gone?
So I'm on my way back, and
How many
I
miles?
was really into conditioning at that time too. So it's late, and I would kind of leisurely ride to the park, and then I would do more cardio on the way back on the straight. So I was kind of doing more of a cardio on the return. So
How far is that?
where is that?
That's got to be.
So
At least
it was
5 miles,
no,
right?
it was like I was 10.2 miles into the ride.
Oh, you'd already ridden 10 miles.
Yeah.
Dang.
So I'm 10 miles in the ride.
Okay.
So I was on my way on the return,
Mm-hmm.
I'm heading on the bridge. Was it Speedy gas station or Swifty? I forget what the gas station. There used to be a little gas station on the corner there, and there used to be washout of pea gravel, and the sidewalks were rough. So you kind of had to be careful with
Speed or
mountain bike.
Mountain bike. At what time would this be?
Well, the citation shows at 440. Well, the citation is 446. We'll discover that that's not accurate. It is actually 456. in the morning. So a vehicle had passed me, or I'm passing a vehicle, and I'm in thought, and the lights, you don't stare at the vehicle's lights, so I just kind of, in thought, I pass it.
The vehicle in opposite direction.
Right.
Yeah.
So I'm heading, and I used to live on Reeves Avenue, East Iron, so all kind of through my life, I kind of always cut through Greer Steel area to go home. So it's just a habit to take Greer. So I'm by Wilmar's. I go through the station and I'm exiting. Going on, it's called Oxford Street. Lightly traveled, more industrial.
Yeah.
Now they have more, there's some off, but anyway. But at this time, this is 99, CVS is under construction. So I'm exiting, and this car comes kind of angling toward me at a high rate of speed. Don't understand. At this point, I don't know so I'm veering off to get away from this vehicle.
Right.
And I continue to veer faster and faster,
Right.
but he's coming at me.
What?
So I don't know how it happened, if I hit the brakes or I turn, or actually if he clipped. I get clipped. I don't know. But I fly over the handlebars at a relatively speed. This isn't like just a little topple thing. I go completely over. Next thing I know, like the officers around, and I start getting interrogated. We might as well get into so here I have photos to have a better description. So here's the back angle of it. So here's where the incident occurred. So I was exiting the drive, and it happens just outside the opposite drive. So I had just crashed.
All right.
And he begins questioning me, and so it's a law enforcement officer.
Okay.
And so here, we might as well kind of go through transcripts. And so this is his testimony. He went over the handlebars of the bike. The bike stopped. He went right over top of the handlebars, took a tumble, and came to a stop. There's further question. What did you ask when you questioned Mr. Gangali? At first for identification. After that, then I asked him to stand up, or after I asked identification, he said he didn't have any. He told me his name. And this is other testimony. He started to get up, and once he was on his feet, he fell back down. What do you mean fell back down? He just fell back down. His legs buckled, and he fell back down, fell over.
You probably have a concussion or
Well,
something.
yeah, so that's the thing. So I'm half knocked out.
Yeah.
And I'm not, it's, when I get into the cruiser after this is when I start coming to and like, what the fuck just happened? Like, what in the hell is going on? So anyway, what I'll discover, and this litigation, so I was in federal court attempting twice. I was in litigation for 2 years, going on like 3. So anyway, I end up filing, there was drips of discovery during the case.
This case?
Yeah. After appeal, while the appeal's filed, I end up going to the county court seeking a freedom of information request. And this is when I finally get some of the documents. And then we'll go through what they did. But anyway, I'll discover, now remember, so I go through 3 years, I go through all this litigation and the hells of what they put me through.
With the union.
Well, no, in this case, because this case is even crazier.
Oh, this case.
We'll discover, so I'll show you the citation, but so 456 Oxford Street on the bike. 457 with the bike. 501, and it seems like Dover Station. So from 4:56 to 4:50, so approximately a minute.
1 minute.
It was arrested. Now here's what I get arrested. So remember, I'm half knocked out.
Yeah.
They're interrogating me, asking me these intrusive whatever. A secondary officer had came. He's the one questioning me, so he doesn't see what the hell happened. Doesn't whatever. Here, he just stood there looking at us. Captain Ever then asked him to perform a finger dexterity test. So they're asking me to do it of the injured thing. So I had stated that I'd rather not, and that's when I got arrested. And I got arrested for operating a motor vehicle under the influence. So while I'm in the cruiser, I'm like coming to now. And now I'm like, what the hell just happened? So if you examine concussions and whatever, and I mean, I biffed it hard. And people know when I say what I mean, like they understand this was a crash, a true crash. And if you see like.
Did you have any visible injuries?
Yeah, my hand had chunks because of the road rash. And I could fit my pinky finger with the size of skin torn out of my one hand. So, I mean, I'm at the station, and they read you this ALS. Well, I'll learn. This thing called the Administrative License Suspension.
So they arrest you for what?
Operating motor vehicle. So,
a motor vehicle?
Yeah, so I'm in the cruiser, and I'm like thinking, so here's what I was given. We're kind of jumping around. So you'll see my citation. It's OMVI here. You'll see crash, yes, this, non-injury, crash report.
No injury?
Well, here. And then we'll get into, here's this document that the ALS. We'll get into that. But 11 months into it, we're jumping around a little bit.
Yeah, so stick with.
Okay.
Do you get to the
Well, I'll discover the goddamn thing's tampered with. Or changed. The court copy then shows injury.
Oh, but then they said no injury?
Yeah, mine has no injury and a crash report. That's scribbled out, so we're getting way ahead of ourselves. And we'll getting all where the. So I'm at the police station, and I'm given this ALS thing, and they read whatever, and you'll see on the ALS, it's a signature of driver, OMVI arrest only. So now, at 4:50,
What does that mean?
OMVI arrest only,
Oh.
operating motor vehicle owner. So I know now this is. Within minutes of getting, so I'm at the station at 5:01. So this 4:56, 5:01 or whatever. So whenever they're reading this, which we'll find the time. So within moments of one, it's been twice that they've stated OMVI, operating motor vehicle, and I know I'm not a motor vehicle. So I'm like, what? And
I'm not signing that.
Well, no, I signed because
You did?
Yeah, it's signed.
I don't think I would have signed it.
So. It's like, I know what I had that night, right? So but I'm going for my destructive devices, and all this legal, and I'm like, well, this is all bullshit. And prior to this, 2 weeks prior, I don't want to get into too much. There was other communications with government, and I just received word, so everything was really weird. Like this whole thing was insane. So it was odd, okay? So here's testimony from the court, employee officer. So here they're using the citation time at 4:56, which 3 years later we'll discover. So here's some more of the testimony. Did you have your window open? So it doesn't even say if he had his window. And it says, okay, after you yelled a second time, he still didn't stop, or what did he do? Well, to be truthful, I was upset. Hold on, here. Did he ever acknowledge you? No. Did he look in your direction? I don't believe so. Did he wave to you? No. So I don't even know what it is.
It's a car.
And yelling out, he doesn't even really verify that the communication, he had his window open.
So he's claiming he was yelling at you
apparently.
or something?
Yeah. I don't recall any, like, while you're milliseconds before you're reacting, you're not like, and then the question is, what was the purpose of the pursuit? Like, what was I doing wrong? You know what I mean? Like, here, and so here's where it kind of gets interesting, or what we want to know, because in the testimony, they'll keep referring, well, we communicated to the station. We communicated when we do it. Like, I communicate. So this time is the radio log would be an accurate timestamp of verifying what the times are, or what's going on.
They're claiming they pursued you because they saw you and the station was calling you in?
No. He's saying, well, we're kind of getting ahead of ourselves. The initial report or whatever, or the newspaper article, was he turned around to warn me to ride on the side, or don't ride on the sidewalk, or wait, turn around to tell me to ride on the sidewalk, and not the street.
So this is the car that passed you before.
Yeah,
he saw you driving, and on the street, he was going to come around,
yes,
and tell you don't drive.
Right. And then I'm run off the road.
Okay.
A secondary officer is also, and then he begins interrogate, and I'm arrested within about a minute. Okay. So you think, so I'm ejected from, like, the state refers to the bike as the vehicle. Their contention is, so I'm literally ejected from a vehicle, begin interrogating, and I'm arrested within a minute with concussion, bleeding. Okay, so here's more testimony. Did you have radio communications with base station? Yes. During the period in Oxford, did you see him commit any offenses, traffic offenses? No. I was just going to pull the passenger window down and yell at him. Let's go here. So he testifies, and this is, I don't even know how, he was about 3 feet away. Before.
That's close.
Yeah, especially on the angled descent. He's not like horizontal with me. He's angled toward
coming at you.
Yeah.
So feet away on a moving vehicle and moving bike.
Here, this is again, took the tumble and stopped. I just saw him. I just saw his body fly over the handlebars, the back wheel going up, and basically a complete topple. I didn't want to run him over. I didn't want to run over the guy. I mean, we're talking short distances. In the suppression, we're kind of. Did you notice any injury or bleeding or anything? He testifies to no. This is in the suppression. So it's weird so he changed one citation, shows injury, the other, so the court file document under penalty of possible shows injury. So what is his injury? But what's further is we'll jump a little ahead, is there's the sheriff and the aid that was given there. So,
where's that paper?
Well, that we'll get into all the depositions or whatever that weren't taken. And so if you kind of look at bike crashes or whatever, it seems inconceivable that the hand injury or you land catapulting over is either I would have had head injuries of smacking my head,
right,
or hand, like some serious, not just brain compression of, you know what I mean? So here's yes, totally honest with you, I have no idea why Captain Everett started field sobriety test. I asked him what, my recollection is he asked me what I was doing, I think the name or whatever. He asked me what I was doing. And I told him I was exercising or whatever. He's like at 4:30 in the morning or something like that. Just while I'm thinking, which was totally honest.
Yeah.
And, well, what are you thinking about? Which would be a loaded question for me. You know what I mean? Like, are you fucking kidding me? He just stood there and here, this is a repeat of. So after I said I'd rather not, I was handcuffed and arrested for OMVI, right? So back to the station. So the arresting officer. So this is what's weird is it's Captain Everett who's doing the questioning, When I say rather not, he says, I'll get the bike, you get him, or something to that effect. So it's like he ordered the arrest, ordered his support to arrest him. Follow me? And that's later important because the telephone or message left on the answer machine. So anyway, I'm at the station and they read me this.
What do they read you?
This ALS thing.
What's ALS stand for?
The administrative license suspension.
So they're suspending your license for...
Oh no, well here's where it gets, so after I sign the ALS paper, I immediately ask for an attorney. And actually it's in the transcripts. And the officer wrote and testifies that I asked here.
Did you have to do a breath test?
Well, hold on. So I asked for an attorney. So Miranda, once you ask for an attorney, the questions and interrogations supposed to stop until you can talk with counsel.
Right.
He throws here, and well, so he throws the phone book at me. I look at it, and then he asked me what I was going to do. I want an attorney.
Right.
Well, then he throws it back at me, which there's trans of the.
What does he read it?
And it says going to take the test. He refused to take the test. Ask again for an attorney. So I'm asking for an attorney, and here, Captain Everett throws him the book again, and he said, how kind of transpired is, so if I ask for an attorney, or do you continue to interrogate and question? Is a phone book legally sufficient? This is why I gave him a phone book. Well, is that an attorney? Is that recognized under Miranda?
Right.
So he's taken a refusal. I said, well, I'm not refusing. I want to talk to an attorney. I want an attorney. And at this time, but you have to understand, everything's escalating. So so I want someone there present. I want to see, because let's think this through here. So you have an armed person, and we'll later understand that the administrative license suspension is construed as a civil action.
Okay.
So they're taking like administrative powers. So they're acting as the judge at this point. Judge, jury, and you know what I mean? So you have armed officer who's the one making the arrest.
Right.
So you got an armed guy making judgments while I'm bleeding. It's that event is a civil action against me. So in the United States, you have an armed person while he's in custody, bleeding, asking for counsel, and they continue and they make judgments. They take it as a refusal, alleged.
Okay.
And what's weird is, so the ALS of the paperwork, if you see date and time, it's empty on mine.
Oh, interesting.
Which is,
that shouldn't be.
Well, what's funny is it'll be later filled in. I'll discover the court documents all tampered with and changed. So to say, now it gets even more interesting because remember this radio log. This is years of litigation. I have to go through a Freedom Information Act or a Sunshine Request Act to get this information. Okay? So now we see, well, they finally released the BAC test sheet, which wasn't part of the scope, weren't providing it earlier.
That was all hidden.
So during trial, this is not provided.
Okay, what does that say?
Not within the discovery. So this is and these are time stamped or supposedly calibrate or whatever. So August 6th, in here, breath test analyzed, blank test 000 at 5:10.
Why?
Well, this is I guess calibrating it.
Oh, okay, gotcha.
Initial standard verification at 5:10. Subject, and it says that I refused, which I contend I did not refuse. I asked for time. And that's at 5:13. You'll see here started observation time, and it's left open.
Oh.
Okay. Here in the form, it says observe subject for 20 minutes prior to testing to prevent oral intake of any material. Okay? So it says 20 minutes. Okay?
Yeah.
Well, let's go back. At what time?
5:13.
Okay, so on the bike, so approximately, what, 4:57
Yeah.
is the earliest time he would have. Well, when are you starting this machine, or what is it?
Oh, they're saying it's 5:15? I mean 5:13?
Right. So there's no way.
So there's 14
so,
minutes.
but
Plus he observed you for 20 minutes.
right. So now we have, and remember, they're
way.
withholding this document. So here he arrested me. What was the probable cause for? And I'm arrested. So what was the probable motor vehicle?
No, none of that.
And then was it
Correct.
a reasonable search and seizure? So the guy who's doing this was it a reasonable search? A guy that just ejected from a vehicle less than a minute. So you break that down is here. I need like if there was discovery or bill of particulars, demand a bill of particulars of the event. So you break down, give me the 60 seconds of what transpired in this arrest.
Mm-hmm.
Here, all these times that they're kind of, or
These times
making it, it isn't.
all made up.
So here, so we have, now remember, during testimony of what the times of this were. So we go back to the citation. Now remember, it took 3 years. I'm already through a trial, whatever. Let's examine the citations.
So at the trial, you were convicted?
Yeah. OMVI. And it's OMVI on the sentencing form. So here, was it an OMVI? So is it defective? Am I a motor vehicle? Influence. I have a witness that was with me the entire night, and this is at 5 o'clock in the morning now. What would anything been in my system? So the constitutional issues of this vague assertion of influence is constitutionally vague. Did I refuse?
No.
The time.
Blank.
8/6. No, it says 4:46.
4:46? What's 4:46 now?
That's what they're saying. This. See, to make, like, if you examine their testimony or whatever, they need that 10 minutes to fit all the shit that they say they did.
So they
They
put the time forward to 4:46 on there
right.
to give them the 20 minutes?
So the actual time is 4:56. So this citation,
my.
if you pull, and then there's a whole other thing of if we had discovery or whatever, or preserving evidence of what the time is. So there's no way he was even at that place, which you allege, or the convict.
Right.
But remember, all this is these documents are under falsification and perjury. The issuing charge law enforcement officer states under the penalty of perjury and falsification.
So
Is
which officer is that?
well, this one's from Roden, and this one, a notarized document that is tampered with, and that's from a notary of Everett, Captain Everett.
Are either one of these gentlemen in
Well,
office or position right now?
We'll get into even more because it
Just
gets.
yes or no?
Well, I think that. Well, hold on. Roden ends up getting indicted soon after
Oh, surprise.
this case,
Surprise.
which goes into, if you ever hear of the issues, if he had anabolic steroids in a system of aggressive behavior, and it's called when you have high doses of testosterone.
Yeah.
There's a term called roid rage.
Yeah.
So, forcing me off the road, there's significant issues. And remember that we didn't get into, kind of jump, the calls to the house. You know, so
Oh, was he the one calling the house?
it appears that way. And then it gets into some, well, if these are under falsification and perjury, forwarded this information to the county prosecutor and the sheriff's department when this was going on. So there's issues of why she would recuse herself, or the prosecutor recused, or wouldn't take up the issue or address the issue. And
So she didn't?
well, she recused, no. And she recused when there was the indictment. So I don't know if being forced off the road, making judgment and bleeding, and this being in the papers and whatever is less significant or of a steroid. You understand? Like the magnitude would be far more greater. So if she's recusing on a steroid case, why wouldn't she have recused when the information was brought?
of what he did in your case?
Well, here, we're kind of jumping. I get down to the officer alleged that I refused, which I contend I didn't. I want an attorney. I want one present, right? I want this documented. Because I'm this is... They asked, who do I want to pick me up? State what my position is, and I'm not going to further... So they cuff me again and bring me down to the county. At that point, I asked for an attorney. And at this point, the offices aren't open, or the public... They would allow me to call the public defender, but it wasn't open at that time.
Treat your wounds?
So that's another thing. So the nurse or whatever gives me gauze and gauze and tape for my wounds. So there's clearly, like, if we had subpoenaed the people there, they would have verified, and that testimony would have been inaccurate.
Right.
And further, now we get, so that citation, I was being held in the county for what?
For no reason.
Well, hold on. So they give me these two citations. Well, we later find out that they're changed in whatever. Yeah. So they're holding me on false pretext, right?
Yes.
And it's defective.
Right.
Like, so there's so many legal issues. That's not where it gets really screwed up. So when I get out, I'm fuming.
Yeah.
So I don't call someone to pick me up. So I'm walking down, and Dominic and Donnie come, and they came and they're picking me up. I'm like, well, how in the hell did you know that I'm, like, what the hell?
Yeah.
He's like, well, this is on the radio, WJ, every hour on the hour. And people are calling.
Does it give a name? Your
name?
Yeah.
Well, they would have known. Yeah. So I'm like, what the? So I called WJ, like, where did you get this information? Because it made me look really, like, where did you get this information? Like, and this guy ran me off the road, like, in this. So anyway, then I call the Times reporter. I'm like, hey, if you're going to run the story, I'd like a comment before you run. So they do an article of the Times reporter, and they have the officers comment. And here so the Times are, but here you see, I caught up with, I passed him and turned around because I wanted to tell him to write on the sidewalk. And then they use...
What time? Do they have the correct times? Or
No, they have the citation charge of what, they don't have the police log charge time. They have and then it says here was charged with DUI, which is completely incorrect. I was arrested for OMBI. Now we kind of have the background of it. I go to the arraignment hearing on August 12th, and the acting judge at the time is Michael Carmella, which was the attorney that I had fired, right? And had so
he should recuse right.
Should have recused, or there would have been an issue. Right. There should have been a recusal, right? Mm-hmm. So here I've been appointed. So here's where it gets interesting. And you see, he was my attorney in this case. He tells people pleading not guilty to go on the hall and sign their own recognizance. So I do what he says, right? Now, I will later discover. Now remember, so I don't get to see the court's citation. I don't get to see their stuff, like all this information and particulars. At this point, I don't know what this ALS is. Here, I'm thinking you're innocent until proven guilty. So I don't know. I will discover that this ALS is different than an OMBI charge. There's one, it's a civil action where counsel's only for criminal cases, right? So you have to either hire counsel or pro se or whatever, because they only cover the criminal act. Follow me? Now, I don't know all this. And I don't know that there's two different charges, too, because they have like 4111-19A1, 49-1.
Which were, what are the exact charges?
So they invert the last two, A1 to A1. So if you don't know what the hell, anything about legal, or you're trying to, you would kind of possibly not understand what the hell they're doing. You know what I mean?
So what did they charge you with? Both charges, what?
Well, there's an ALS that you don't know, and apparently you can appeal that at your initial appearance, or contest it, and raise issues. Well, I don't know that. I followed what the fuck the judge told me to do.
Well,
And I don't know that this ALS, like how it exists in this realm. It's an appeal. So if you would have told me, hey, no, that armed officer is making judgments while you're bleeding, I'd been like, what the hell are you talking about?
yeah.
You're taking what transpired in that
Yeah.
as a legal proceeding?
Yes.
It blow your goddamn, like, holy shit.
Yeah.
Like this country,
That's what
like
they did.
this is Nazi Germany shit.
Yeah. Yeah.
So anyway, here, duty of law enforcement. Now we're kind of getting ahead of ourselves, but here it says law enforcement officer issuing a citation shall sign the ticket, serve a copy on a completed ticket on the defendant without necessary delay and file with the court of record. So here, there's a duty of the officer to have a completed form and file it with the court. Okay, just so we're clear on that, right?
Yeah.
Here, rules of civil procedure, rule 13, well, rule 3, excuse me. This is about the citation and how they're the 3 sheets, because we'll later discover it's tampered with. Well, how does it get tampered? But here, rule 8, arraignment. Arraignment shall be conducted in open court and shall consist of reading the complaint to the defendant or stating the substance of the charge, calling him to plead thereto, and defendant shall have a copy of the complaint or shall acknowledge receipt thereof before being called to plea. So I never had, well, I have something different than what the court says. Under falsification, perjury. Right? But they tell you to go out in the hall. Explanation of rights. So here, he has the right of counsel, right, a reasonable continuance. So here, we'll go further. Rule 11, motions and pleas. Any defense, objection, or request upon completion determine the trial thereof. Here, following defense raised before a plea. So if I wanted to contest things or whatever.
It should have been.
Right. So here, the initial appearance, a criminal defendant's initial appearance before a magistrate where he learns the charges against him and his liberty is subject to restriction marks the initiation of adverse judicial proceedings, which triggers the attachment of Sixth Amendment right to counsel. So they're violating the rights of counsel. Due process, equal protection. If I have to plea before, so I don't have the...
Right.
So here, and then in McClellan...
So they make it so they...
Hold on. In McClellan, a person arrested without a warrant is entitled to prompt determination whether there was probable cause for the arrest. A delay of more than 48 hours was unreasonable under the fourth holding. McClellan application. So here, in McClellan, if there's a violation, here, raise the question whether the exclusionary rule is applicable when there's been a McClellan violation. So in this case, County of Riverside case, that gives you the right to the probable cause, right? So my attorney, it takes...
Within 48 hours.
Well, here, so it takes weeks for the assignment of counsel. Okay? I have a case of why there was no probable cause. It's defective and whatever. So he files a motion to suppress because a valid motion to suppress. But what's interesting is they set it up that motions, there's court rules that has to be filed within 35 days of the motion. So here, you're starting the clock at the initial appearance, but you're not following any of the rules of criminal procedure, which requires the attachment of counsel. Okay?
Right, yeah.
But then they put counsel under the burden.
The time frame.
Right.
You got an attorney then?
So there was one appointed because of all my legal shit going on. So here, a general prior representation of a party who one is now a judge is a disqualifying factor. So he should have never been. Ohio rules of, or Ohio Revised Code 2937.02, superseded by Criminal Rule 5 and 11, are mandatory upon a court. So the rules of criminal procedure are mandatory. And there's Constitution here. A preliminary hearing is a critical stage which the right of counsel applies. The right of procedural due process is not conferred by legislative graces, but by constitutional guarantees. So there's the rules of criminal procedure, there's the rules of Ohio Revised Code, and there's the constitutional rights, which are all appears to be violated
By putting
by this court.
time frames.
Well, by this court. So they don't tell you the chart. And this is October amended. The rule authorizing contempt proceedings before the Supreme against any judge, clerk, or other person who willfully fails to apply or adhere to Ohio traffic rules, which those were. So they don't worry about, there's issues of they're not following the rules of criminal procedure. When you deprive of those rights, you're entitled to seek habeas corpus relief,
Did you try that?
which counsel didn't do. Instead, he filed a motion to suppress, which is not what McClellan raised. There was an issue that's not the proper remedy. And actually but here's where it gets, the defendant did not waive his right to the speedy trial. He intentionally did not do that. I filed a motion to suppress. Okay? I know that's not what, here. You file leave, which I don't know what that means, but did you ask permission to do it, right? I'm sorry, I filed a motion for leave because it was out of time. And this is the counsel. Past the 35-day, well, it says day. That's not uncommon because a lot of times we do not get the paperwork until the time is up, or at least we don't see the defendant until the time is up.
Okay. Yes. So this is commonplace.
So this is common practice to skew
So
the initial appeal.
This gives the court the option
to deprive
somebody,
right, or put people choosing between rights.
Yeah, they choose if
right. And
who they
right,
allow
and if
through
you,
or not.
and then remember, if
under
you
that
got
time
paid
constraint.
counsel, they've got the heads up, or they have the so there would be a legal question or if they did a federal inquiry into it, if it's prejudice toward indigent, whatever, and willfully. Now remember, rights and privileges. So did a judge know that there's rules of criminal procedure?
Of course.
So then they willfully and knowingly so.
They
Under 18 U.S. Code, so 18
up.
U.S. Code, there would have been probable cause to believe that rights were being violated. Now we got to get into this. Wait a second.
You're uncovering a lot of the little tricks that the courts do.
Then you say, wait a second. If this is going on continuously, how did counsel, how did goddamn prosecutors, how do law enforcement go on there in a regular basis? They're connected to there, and all the firms knowing that this is going on.
Yeah.
Do you have a duty to report the ethics?
Of course, but they're all in cahoots again.
So wait. So now, if there was a federal inquiry or this is discovered, then you have to wonder. Well, I need the names of everybody that went in there, the logs, and you wonder if they failed to comply with constitutional sworn oaths, what they were doing.
Sure, they did.
And then that attaches to the firm. All these counsels, and then if they're representing other people or in other courts. Then you'd have to notify them. There's wait a second, were they being honest or forthright, or is there an ethical problem with what's going on here?
I contend.
So here, 14th Amendment.
This goes.
14th Amendment to is no state shall deny any person within its jurisdiction equal protection of law, all power. So, is there? But hold on, this is what Judge Space says. I don't mean to hide it. I know some courts do that. Don't say that they're doing it on the record. So
Don't say they're doing it on the record?
Right. So we know that this appears to be a systemic problem.
I am doing that, and I feel I have to handle it that way because otherwise I'm going to have time problems in cases. And from my point of view, okay, so he's admitting to this, that this happens all the time.
And it's her point of view, not the constitutionals, whatever. It's my point of view.
I don't mean to hide it. I know some courts do that.
Oh, so
oh my God.
Here, I don't mind putting this on the record.
That's fine, but the situation that the court is in, and I don't mind putting this on the record, at all is that everyone has a right to speedy trial. So I'm under a burden to get the cases in within time. Sometimes it's very difficult because the docket. So she's giving us the excuses of why.
But remember, the rules of criminal procedure aren't being followed.
But she's okay with it.
So now comes so Gary, I have a meeting with Gary, and I'm thinking, I told him, listen, I don't want to waive my right to the speedy trial. I want my speedy trial. I didn't do anything. Like, just get this damn thing. And I remember, I have tons of legal issues as I am. Now I don't have a driver's license. It's going on months.
Oh my gosh.
So I'm in a meeting with him, and I think we'll talk to counsel or talk it over with him. So anyway, I end up having a meeting with him. I'm thinking he's gonna motion for a reconsider, have her reconsider what the hell she's doing, because it appeared to me straight out that they were violating the rights of speedy trial.
Right.
So he ends up filing leave to file in a motion for reconsideration. So he ends up waiving my right to get that goddamn suppression in. Now, I don't know this. He doesn't tell me.
Why does he do that? To save the courts?
To get the suppression, because he feels that there's a valid suppression. Okay? He's also taking a vacation or something, which I don't. But so Gary ends up filing a motion. So remember, in that comment, that it was already filed. I filed a motion, right?
Yeah.
And that will later come in the motions. So here's his motion. Investigators lack probable cause to arrest the defendant for. You see what that is?
Mm-hmm.
OMVI.
Mm-hmm.
In addition, suppression of all orals, or whatever. Fifth and Sixth Amendment, right? Defendant was arrested for what is this?
OMVI.
Right. Terry versus Ohio. Russ actually created a danger to the defendant.
Mm-hmm.
And so Cloffer versus North Carolina, the pending of indictment may subject to him to public scorn and deprive him of employment. Also, certainly will force curtail of his speech. So anyway, this one, anxiety. So here's Cloffer versus North Carolina regarding speedy trial. Okay, a federally protected right. The fiduciary duties, or I told him I did not want him to waive it.
Of course,
so he
should be doing
bucks
what
me,
you
right?
Yeah.
So and the arrest was for motor vehicle.
Yeah, what's the definition?
Motor vehicle means any person propelled or drawn by power other than
muscular power.
So it's.
Are you serious?
But it gets here. So
it can't possibly be right there. It's blown in the water.
Then what does influence mean? So I have a witness that was with me all night, and this is at 5:40. Fundamental matters which counsel must abide by the client's decision. So is the speedy trial right a fundamental right? Mm-hmm. So there's issues that even if they attempt to buck you, is it fundamental that they can't override it? Waivers must be voluntary knowledge.
Must be knowingly intelligent acts done with sufficient awareness. Yeah.
So there's.
You weren't aware that he was going to do that.
And this is a footnote too. In the early days of the Republic, prosecutor was simply anyone who voluntarily went before a grand jury with a complaint. So this will be interesting in later issues, okay? So while this is going on, Uncle Sal calls me and needs help in Italy. And I was talking to Ely and some other, actually European companies for my thing. So I was like, this is great. I can go help him. I need some time, whatever, and right. So anyway, I'm rushing to get shit and prepping for the flight. And again, so I get pulled over, and here my license is suspended. I get driving under suspension by Dover police. Now I'm furious. Well, so I get the cars impounded.
What were you pulled over for? Or were they
Speeding.
watching for you?
Speeding.
Speeding.
I'm wondering when this case is going to happen. We're going to get this goddamn thing through. So I called the court. First I learned my counsel waived my right to the speedy trial. I'm like, what the fuck? So I call him, like, wanting to understand, and I got to tell him, hey, I've got this trip. I need, whatever. The secretary's like, hey, he's been on vacation. he has nothing to say. So by this, I'm like, what the? So I'm pretty upset. So when the driving under suspension case, I'm like, well, I'm not going to let these guys, everything that, like he had called and didn't return my call at the jail.
Oh, this was the same attorney,
Yeah.
the Gary?
Yeah. So that, like, then this stunt,
Yeah.
right? And whatever. So I'm like, anyway, I end up this again. They don't follow the rules of criminal procedure or whatever. This time, I don't waive my right to speech trial, and I have a trial, and I'm pro se.
Mm-hmm.
I raised the issue of, hey, there's supposed to be a suppression. And remember, the suppression is to suppress illegally obtained evidence in courts. So she's using the ALS, which is derivative of that event, for this. This is what caused the driving, right? So I end up getting convicted. Well, it was supposed to, I believe, contingent on the driving under, or on the, but later I get in the mail or whatever that I'm get. So here, the exclusionary rule. So if the exclusionary is to prevent it from being used, here she's already hedging and using it.
Right.
So we know that this is no longer a fair and impartial venue, right?
Right.
Then I discover I was appointed in the driving under suspension case new counsel of Ron Collins. Ron had been the one that was in charge of this case, so there's a conflict. He prosecuted me in the past, and I believe there was times that he was being prosecuted for a domestic violence at this point too. So there could have been issues of.
So he should have recused once again.
Issues of conflicts of interest, and if there's.
Right.
Oh, and while I'm at the suppression hearing, Ron doesn't have the suppression, like the file. So I wait months to get this goddamn thing in a suppression, and here he doesn't have it. Right?
Why?
We're waiting.
Greg has? Gregory?
Right, or didn't, like, he copied my folder. I didn't have what he didn't send me. So here's issues. Well, there's issues that Roden later gets indicted, and the aggressor.
Oh, did he?
So here, did you notice any injury at the suppression? He's like, no.
Yeah.
So I knew that wasn't true.
Right.
So I go to the jail asking for my records, whatever. They say they didn't have any of that.
Oh my God.
So I'm not getting any discovery or whatever. Remember, and I was the writ of habeas corpus. So if you're illegally being held, you have the right to seek relief in federal or in court or in a habeas corpus. And that was there ever a probable cause hearing to determine the facts or whatever? So we knew that the judge was hedged. She found me guilty using the evidence that she was going to be ruling on.
That hadn't happened yet.
Right. So
that hadn't happened yet.
So then I'm like.
So she found you guilty.
Yeah, I think she mailed because I think it was
on what should have been.
So then there's rules
withheld until a prior case.
Well, it shouldn't have been, because now I have the right to the speedy trial. So if they couldn't get the suppression done in time, it should have been dismissed.
Yeah.
So
they still
they're going to use
you on something that hasn't happened yet.
And I think the rules of criminal, you have to be there for sentencing, and I don't think I was there. So if you pull the transcripts or whatever, I wasn't there. So that's another rule violation. But so here, it was taking now, like we were going on.
Do they know what they're doing?
So we were going like on 11 months now.
Do they
and they had hold on. So the suppression, it was like, there was nothing in my mind that this was not going to get like.
It had to.
Right.
There's no way.
So I'm like, what the fuck is she waiting? So I knew she was hedged, and then so finally I went to Gary Gray. Like, we have a meeting at Gary's, which is across the street from the police department, or was. Or excuse me, Ron Collins. And we walk to the courthouse. We have a meeting and whatever. And remember, this is going on, and I still didn't have my driver's license at this point. So we go to the court, and this is during cases. I sign in, so I have the date. I know that I signed in, and he actually was already there, and they let him skirt through and not have to re-sign. We go up there, and in between cases, he goes and talks to the judge. Okay, so this, we wait for a little bit, so there was time, and then they go in. He comes in and starts asking me these weird questions. I'm in the hall, like I'm peeking in, but I'm not inside the courtroom. He starts saying, now, while this is going on, there's people in the hallway where they're waiting for their cases. And they're like saying this is weird, So I'm like, man, this is just... So then he goes to the clerk's office, which was down the hall, and has questions. Then they go back to the judge. And then this whole thing was really suspicious. And I know she's fucking hedged, right? I'm like, so then it's like, she's going to go for it. I know she's going to try to buck this. She's going to... in my gut, I know she's going to go for it.
She's just going to do something
Whatever.
against the law.
I know she's going to do something. So I'm like, fuck it. I'm going into federal court. I'm going to seek an injunction. Because at this point, we have the issues of being forced off the road, the crash. Things weren't matching up. So here...
So what did she do?
Hold on. So I tried to get into federal court. So that one case that we're talking about, I filed for an injunction.
What happened that day?
He talked and we ended up leaving. I think it was like 40 minutes.
And then you just left.
We left waiting for her to roll. But listen, it was so goddamn...
So in the rule, so she did rule and you got...
Well, at that point she hadn't. So I'm like, she's going for it. She's going... right? What is she... By this time now, she had already convicted. So it's like, what are you going to do? Reverse course? Right? You know what I mean? They're 2 months... They're a year into this case now. And say, well, we made it... they ain't going to admit they made a mistake or do... So my gut was like, they're going for it. They're going for it. So get into federal court. Fucking get this... Pull it. Right? Because we knew something, I knew the facts, right? And I know something's, we know that this is bullshit.
Right.
And give me in somewhere where I can fucking get in the doc, really rip them apart.
But it's kind of funny that...
Title 42 U.S. Code, which authorizes suits of equity, redress, deprivation of rights, is within the exception of the federal anti-injunction status. So hold on. So the judge... Here, stay of state proceedings. Here, Riverside versus McClingan. McClingan brought class action suit, injunctive declarative relief under 42 U.S. Code 1983. And here, the district court never ruled on the motion to dismiss, but accepted a filing of second amended complaint. So when you read County of Riverside versus McClingan, so I initially, that one case I'm talking about, I go into federal court. Remember, and these are supposed to be a warrant promptly, the right of due process, brought before a neutral judge. So there was supposed to be probable cause determination from a neutral. So the initial appearance judge in Space did not seem to be fair and impartial, right? So anyway, here's the opinion from the federal court. Even literally construed to complaint does not set forth allegations suggesting Mr. Nga has a valid federal claim at this time. By all appearance, the constitutional claims he asserts 6th and 14th involve cases that are still pending before the Municipal Court in New Philadelphia. Federal interference in state criminal proceedings is disfavored, and the only exception to the rule in such interference is irreparable injury, both great and immediate, to federally protected rights which will otherwise occur. Younger versus Harrison. There's no indication from the petition that his execution of the role is warranted in this case. But here, habeas corpus is a proper remedy where the defendant has not been afforded a preliminary hearing within the prescribed time. That's a state. Federal courts have continuous artful pleading, liberally construed by prosecution. Here, court has emphasized taking into account the fact that the petitioner is usually handicapped in developing the evidence needed to support necessary details in the facts alleged in the petition, that habeas corpus must not be allowed to flounder in procedural morass. So there's great issue if that federal ruling, if there was, or I wasn't allowed to provide necessary details. You know what I mean? But here's where it gets interesting. In the court's finding of fact, it says Mr. Ngali was arrested for operating a motor vehicle under the influence. So in his finding, now federal court's finding of fact, it's OMVI2. Okay? Now he rules after Space had ruled in her opinion.
Afterward?
Right. So she ends up ruling a couple days. So I file it, and then she rolls. Here it is. And boy, what a whammy. So here, entry, judgment entry, right?
Yeah.
The defendant moved the court to suppress any and all evidence found pursuant to the stop of the defendant's bike. So she knows that there's a bike.
For the reason that said stop was not based upon reasonable suspicion derived from objective, articulable facts, and that the investigating officer lacked probable cause to arrest the defendant for OMVI. Correct.
So she knows. See?
OMVI. Yeah.
So wait, right here, the officer lacked probable cause to arrest the for OMVI. So you're telling me he had probable cause to arrest for operating motor vehicle. Right? So she wrote this, and she. Do you see that paragraph?
Yeah.
It's more interesting. Short pursuit. The officer never effectuated a stop. What the fuck? Mm-hmm. What was it then? But here, the officer admittedly was in short pursuit, but did not effectuate his stop. The court finds the defendant crashed his bike on his own. Where did she have any due process, whatever, of determining how in the hell or what caused the crash? But go on here.
Yeah.
Gives you so here, this is where it gets interesting. The court further finds the defendant gained probable cause to arrest the defendant for what?
Driving under the influence.
So she switched the goddamn
DUI.
charge. She switched the particulars. Now, what you don't find out or disclose is the officer worked for her court too. And her husband's good friends with the law director at the time. Failed to disclose this information. Now remember, so she rules on this, which is bullshit, right? I get the federal court opinion after hers, right? Now that opinion says pending cases.
Now this was over though. It had been on.
Well, hold on. So pending cases, so that driving under suspension isn't no longer pending. The crash was that a pending charge, or what are we doing with that? And the ALS, is that a pending? So I'm wondering what the fuck is all these charges like? So in that federal court opinion, what's pending, right? So if I can get relief on those, it gives me relief in here. You follow me? So I'm calling the court to wonder what is this ALS, because it's no longer pending, right? So I'm calling, and they're giving me these weird explanation, which I just can't figure it out, right? So I end up drafting up some petitions. Here's the appeal. We're going to jump way forward because the slide's here. The appellate attorney is Michael Pewterball, which was appointed, which took months to get. I think it took 2 months of appeal. He's friends with Zach Space, and he represented the officer in his steroid. Mm-hmm. But look what the trial court erred in overruling the appellate's motion. Now we're jumping way ahead here. The police officer lacked reasonable activity to warrant the stop and probable cause to arrest the appellant for driving under. That's not the suppression that was filed, right? Gary Gregg filed OMVI. So he's using the judges, and so we'll see if there's conflicts there. So anyway, I prep a petition to file it with the court. Okay, the definition of stop in Terry versus Ohio, they reject. If you're stopped and seized, it's a stop. But anyway, so I go on September 13th to the courthouse. and I got the 3 petitions, and I asked it to examine the 3 files, driving nurse suspension, the ALS, whatever. So I'm going through the files, and I'm on the OMBI case, right? And I see the citation, the courts, and I'm thinking, this isn't like mine.
Oh.
And I'm like, and I realize
it's all scribbled.
So I realize it's tampered with. It's changed. Now remember, this is under falsification and perjury.
Is it really? It's all scribbled.
And she just rolled on the crash, which now it appears her, right? And in his suppression testimony, there was no injury. It's marked injury.
Mm-hmm.
So now I'm like, what do I do? And here I'd commented, like under my breath, I'm like, oh, they're covering up. And the court staff heard me. So now they're kind of defensive or whatever. I'm not leaving. So they asked me, so I was like, I need the document. So I says, I want to file my petition, or I want copies or whatever. I want verification, because they destroy it. Everyone destroys your ticket.
And you don't have a phone at this point where you can.
No, this is 1990, 2000, right? So they end up calling the police department on it.
Oh my God! For trying to get information.
So, well, no, I'm trying to file a petition. I'm trying to file the documents and document what the hell's going on. And an old classmate of mine's younger brother and another officer comes. He says, I walk you through what I just discovered. Right? So this is their interpretation of what transpired. The officers were called to the municipal office Thursday morning, where a man they report was being unruly with employees. The man, they said, was upset about how the paperwork is being filed with the court. Here, hold on. This is so on September 14th, or what is? No, excuse me. I don't know when what day was this? It might have been the 13th or 14th, because this is dated the 15th.
The next time.
What's funny is I tried to get a free information of this and other materials, and they say they don't have it on New Philly. But anyway.
In reference to him receiving a ticket on 8/6/99, the
patrolman
wrote in
seems to appear different.
Original copy seemed to appear different from the original. Document from case number 800 has AIS paperwork with case number 9909773. Was refusing to leave because he wanted a crime scene established.
Hold on.
3 petitions, timestamped.
So I either want to know timestamped or written
request
that they were
presented to the court.
So they refused to file a petition, a First Amendment right. A defendant in a criminal case, they refuse to file when you find this, right? So here, every moment continuous strain amounts to a flagrant, indefensible, and continuing violation of the First Amendment. It is established denial of First Amendment, even for minimum periods of time, unquestionably constitutes an irreparable injury. See here. Now this is Judge Paulson, the federal court injunction that I tried to get relief. Now I just found that there's tampering under falsification and perjury, right? In the crash, and they're not the driving under suspension and the LS is not pending, right?
Okay.
So let's just, and if I have the right, or if the exception to the Anti-Injunction Act gives me right to go into court to seek relief. But here, however, it's beyond dispute the federal courts have jurisdiction over suits to adjourn states officials from interfering with federal rights. So did this act of obstructing or tampering with, or of depriving access, did it trigger an irreparable injury and immediately seek relief in federal court? Is this a violation? So when this happened, after I filed that, the law director of Dover dies on September 17th, or 2 days after this was. So this is on 9/15. He passes away 2 days later. Now, let's look at just the issues at this point. So the issues of unjust pursuit, unclear distance, issues of being forced off the road, crash, bodily injury, issues of excessive force, issues of gross negligence, issues of unlawful intrusion, unless they're asking me questions like invasion of privacy, issues of illegal search and seizure, issues of lack of probable cause, false and or unlawful arrest, unparticulars of the charge. Oh, there's no accompanying charge. Doesn't lack of Miranda, deprived, informed of wanting counsel attorney. Oh, summary. So you have armed officers making judgment while I'm bleeding. Unlawful detention issue. Oh, so then the remember, this is being broadcast on the radio. So I'm being publicly scorned, and they didn't even do a probable cause
fell
here.
off a bike.
Yeah, everybody's making jokes about it, and they have no idea the magnitude or what the hell was going on. So here the Times reporter, and they misrepresented the particulars of the arrest. In fact, deprived of a detached magistrate, deprived of critical procedures of the initial appearance, deprived being informed of the particulars of charge, deprived of notice of the charge, the issues that it's constitutionally vague of influence. There's a violation, deprived the assistance of counsel at the hearing. Oh, and also on...
You were held for 8 hours.
The issues of constitutional right for habeas corpus proceeding, the right of access to legal counsel when you're doing habeas corpus, so they failed to provide assistance in the preparation of the writ or the civil rights issue. Hold on, the exclusionary rule. Now we still have the issues of the speedy trial issue, and then here we have the issue. So I'm in these proceedings how many times in the court, and now I discover the state at no time disclosed to me that the citation had been changed.
Why would they? They changed it.
Well, you're supposed to provide
to protect
the
themselves.
discovery. So, do you have a prosecutorial misconduct issue? Disclosure. Supreme Court has held that Brady suppression occurs when the fails to turn over even evidence that is known only to the police investigators and not the prosecutor. An individual prosecutor has a duty to learn of any favorable evidence known to others acting on the government's behalf in the case, including police.
Good luck.
So they failed to disclose that and remember, we're still, so when I discover the tampered citation, I go back to the county police department. Then they give me the booking report where it showed stuff that I wasn't under the influence. So they withheld that. So now I have a ticket under falsification and perjury that's changed. I'll further then discover that the ALS is tampered with. Now that's what gets even more. The law director of Dover ends up passing. Guess who appointed to fill his position? The judge's husband is appointed. Now that raises serious constitutional issues because now he's overseeing the prosecution of things that his wife had done. Right.
Does anybody else see this?
And this is after the untimely death. Friends and family members encourage Zach to become his successor after gaining his appointment. So here, when there's a conflict of interest or whatever, you're not supposed to advocate something. Here, a judge shall not accept or shall urge the spouse's domestic partner or other family member resigning to not accept any gifts, loans, benefits, or anything of value. So here he's accepting the appointment. So is she supposed to be advocating?
Oh my God.
So here,
why did anybody else stop this?
And here, this is what's interesting. Space is given a high ethics reform package. So here she ends up recusing herself.
Oh, from years? After all that?
So she disqualifies herself and gives me 3 options. She could either stay in place, a magistrate, or get appointed by the High Supreme Court. Now, does any of those options remedy the conflict that is now you're going to have a case where she rolled and her husband's overseeing it, and you have all these legal issues? Does whatever the court does at this point, does it dissolve
No.
this issue.
Right.
So there's a stay in the case till the appointment of
A judge?
Visiting judge. At that point, I petition Dover Mayor, and then I go to the county or New Philly law director.
What are you asking for?
Well, they know, so he's overseeing the law, right?
Huh?
A law director oversees the prosecutions or the conduct in their town.
Okay, so what are you asking for?
Well, so I inform them of what's going on because here, if the rules of criminal procedure aren't followed, those are no. So you have misconduct, and now you have a judge and her husband in a case, and she's making these rulings. So if there's any misconduct or any ethics or criminality or well, so but now he's on notice. The town is on notice, and you proceed or whatever. If there's any liability later, or we discover, well, you definitely knew. He tells me to contact the Ohio attorney. So this is law directors.
Of Philly?
Yeah. So he refers me to the BCI and the police officer, chief of police safety director. Now, what's interesting is BCI, I contact them. And so remember, these are under falsification and perjury, right? So I got tampered documents that are filed with the court. So BCI doesn't then launch an investigation unless there's been a referral. So they refuse to
take it up.
So I called the county too. So I went to the sheriff's department, notified them of what was going on, and the county prosecutor. So, but these are tampered, right? So here, 18 U.S. Code, deprivation right. Whoever under the color law, statute, ordinance, regulation, custom willfully subjects any person, state, territory of any rights, privileges, or immunity secured by the Constitution or the laws of the United States, or indifferent punishments, pains, or penalties. Anyway, it's 18 U.S. Code is federal crime, willful, and then 1983 is civil rights action. It took 5 months. Now, I attempted to appeal the federal court's opinion in federal court, in appellate court. So it gets rejected so it never gets examined. There's a pretrial hearing. Now, at this point, now remember, now I got appointed a third counsel, right? So at this point, I want them to show jurisdiction. So they did, like, there's, I think, case law that affirmed that they had jurisdiction. They didn't do those proceedings, so there's questions if they actually have jurisdiction. And then all of the conduct is if you violate rights during the proceeding, you lose authority in a case. So prove jurisdiction or prove that you have the pretrial.
Mm-hmm.
And I was appointed third counsel.
Is this for the OMBI?
Right.
Okay.
Now, my third counsel, we have the judge before she recused is appointing him.
Mm-hmm.
So are there issues of conflicts of interest with that? Then he works for the firm that was the first one. So is there conflicts of interest with that? And he has the private practice, which I had a case that was within the same office. So there's multiple conflicts of interest or issues, right?
Yeah.
So here's the pretrial, Mr. Gingal. I don't see how her husband's appointment, the court, whatever it is. I've been appointed now. However, appointment by the Supreme Court, and those things seem to be ordered. There are a number of cases and other cases that I'd have dozens of cases and say in that situation, and I'm not going to go behind that. We'll have to just wait and see. So that he knows that there's potential issues of conflicts of interest,
but he's just not
and the judge is going to kick it down the road.
I'm not looking.
And so I'm going to let shit happen.
I'm not looking at
right.
that. That's it. Simple, done, easy.
So here.
No responsibility.
So then I'm wondering. So my counsel doesn't seem to be wanting to. So here's representation by counsel. If there's some defect in the citation and all that, I think he can present that on your behalf. But the prosecutor's not prepared. I'd say it'd have to be done in writing. The prosecutor's not prepared to respond to an oral motion at this time.
Huh.
So here, if you check the filings or whatever, you should be entitled to raise issues at any point in the proceeding. Knows that there's issues of defect in the citation. One of the federal questions, why is he not raising? Is there effective assistance of counsel? So here, are we addressing the ALS in this matter or other cases?
Or the other case. What is the ALS?
So I think in view of the facts that at this point the time has expired, it's been almost 2 years without a license, and so here I'm going to vacate the ALS, which was never
You
vacated.
had a win there.
Well, here they never do it, but then it raises legal issues. So here are the
Wait,
issues.
she was waiting on that one.
No,
Did you do your
I've been
second?
already punished. I did the whole thing or whatever. This is the visiting judge, so there's issues that it was supposed to be vacated and they didn't. Now once it gets vacated, then it raises a whole other set of legal issues, because now I learn that the ALS is a civil action.
Mm-hmm.
Okay. We will further learn after conviction it infuses with the OMVI.
Mm-hmm.
Okay.
But he just vacated.
Well, hold on. So the standards of so how are you switching that? Because the constitutional right to have reasonable doubt, or so the standards of that, the speedy trial, all your legal protections of a civil case, if you're infusing it in a criminal, you have to have different legal standards now, and rights of counsel and all that.
Okay.
Okay.
Right.
Oh no, but now here's where it's going to get even more. So you are infusing the civil action.
Which has been vacated.
Well, they didn't. So here, let's say
He
so
was going to.
we're scheduling it for trial, right?
Okay.
Now, so you're a prosecutor, and you know that the ALS and the OM
Are connected.
are going to fuse
Yeah.
after conviction.
Uh-huh.
So we have now tampering of this one.
What's this one?
This is the ALS.
Now they tampered with this one too?
Yes, this one's tampered. Now, I had thought that it was coming from the same department. I thought all the tampering would have been from the office.
The policeman.
Here,
It's the
during
prosecutor.
trial,
It's the prosecution.
they had the originals. So I'm at trial, and I believe it was the state giving the ALS. Now I realize it's coming together, because that tampering probably occurred at the Ohio Bureau of Motor Vehicles on the driving under suspension or when it was filed. So now we have multiple jurisdictions with tampering, and now they're infusing. So now we have multiple jurisdictions and multiple entities fabricating and falsifying documents. Are you following me? And that exponentially. So now we can get so if 2 or more people is conspiracy to deprive of rights, they prep it for trial. So remember, Steyer, he's got the issue. He was appointed by the judge. He's working for the other the same offices as the one who waived it, which that issue of conflict of interest, and the he has other offices where there was another case. He shares offices with someone. So he files a motion and seems to omit that the rules of criminal procedure ain't followed. And the 35 days, motion to dismiss for want a speedy trial. Defendant contends the previously attorney defendant signed a waiver without approval. Here, the court, for the sake of determination of this motion, assumes without the defendant did not know here. Held that attorney has the authority to execute a waiver of a speedy trial even without the knowledge of a defendant. So, one, is this in conflict with Cloffer versus North Carolina? Is it a fundamental right that has to be
Knowingly?
voluntarily and without? And he doesn't put in why he had to waive the speedy trial. So that would have raised the issue. Well, the rules of criminal procedure aren't being the time, the equal protection clause of the 14th Amendment weren't followed. So why does he omit that? And be 3 months or more before the trial begins. So this is May. So I'm like, what the fuck? So here's where it gets is so if there's a false arrest or the statutory limitations is 2 years on a false arrest or excessive force claim. So there's certain tolling things.
Yeah.
But pending trials.
So it gets extended.
So yeah. So I'm under. If they kick it down the road and then just whatever, I was under problems. I filed the petition in federal court. This is the one that I get permanently barred access because now. And I name the so I file a petition, a First Amendment petition. Okay, so if there's any misconduct or whatever, or hey, we convert a grand jury, like if there's probable cause for crime, you know what I mean? Like, I didn't set the relief. You follow? So I'm using a First Amendment right, not a congressional act of 1982. At this point, so I knew at this point the answer to the complaint. And that raises some serious conduct by that court. Okay? Now, do I just let it go or be like, you better raise it and call it? And then we look back into, because remember, this federal judge, in his federal court opinion, now he made findings of fact that it was OMVI, right? So you guys really did some shit that I'm actually trying to figure out what my best avenue is from your fuck ups. So anyway, now so what, so the fiduciary, here, so in the suppression, defendant, and here's where another thing, defendant did not waive his right to, he intentionally did not do that. So here's the problem too. Is this we don't not get our paperwork until the time is up, or we don't see the defendant until the time is up. I want to know why in the hell that's possible, and how many people know that this is going on, and why that wouldn't have been in that motion. So then here, they had subpoenaed the corrections officer at the county jail, or he waived them off, the deposition, which is, so you have all this tampering, you have all these whatever, and they don't ask for a bill of particulars or verification, or what the hell is the particulars of the charge? Like, is it OMVI or is it, do we take the federal court's finding of fact, is that supreme? Or is it OMVI? Like, is the trial court, Judge Space with her husband, is her rulings void, or we accepting that? Like, all these legal questions, right? Tampering. You don't. When does a criminal defendant in the United States get a copy of the complaint?
Yeah, it's
at what point? So we just switch.
Right, up, down.
So I'm fed up. Right? So anyway, when I get kicked out of federal court, I went to state court, co-concurrent authority, and I named the officers, the court, and the Ohio Attorney General, or the Ohio Bureau of Motor Vehicles, which the Attorney General. So now they have knowledge, and it's public record, right? So and Steyer. Like all these issues, what about is the ALS going to be used in the case? Which citation is going to be used in the case? You know what I mean?
How can the ALS if it was vacated?
They didn't vacate it, which is. So
the judge said to, but they didn't.
And if it got vacated, then then there's issues that I had the right to seek federal, because then it gets vacated.
Right.
Civil rights actions, and that. But now, when it infused, it almost compounded, because now you're infusing a civil action tampered with multiple jurisdictions, which really, if it ever had a federal inquiry or whatever, it's like, I wanted to have Steyer off the case. And the court refused to dismiss counsel. So there's the Sixth Amendment right of criminal defense. But that's not where it gets. So here's when the federal court permanently barred me access, which there's legal issues. Here, his illegally charged, and here, so the state, sues Dover Police, and so here charged with OMVI. So this is the civil rights action.
Writer?
Yeah, so they knew that it was OMVI before they began the trial. So when I sued him here, then the officer ends up calling me and leaving.
Who did you sue?
I sued Roden and Captain Everett, the county court, or the Muni court, and the High Bureau of Motor Vehicles. So then, here's so the attorneys would have had to have knowledge of that too. So if there's any misconduct or whatever.
Was this before your case got?
Right. So then they suddenly, when I got the threatening phone call and filed that, remember it was supposed to take 3 to 4 months, right? They suddenly fast-tracked.
Oh.
But then they wouldn't let me
Change
defend myself. Yeah. So I have, and he wasn't going to challenge the integrity of the officer. He wasn't going to. So here's the best one. He admits that he changed it. Does it look like the final? Oh, and there's. Oh, let me go back.
How did it even
Here,
get brought
on
up?
one of them I changed. I don't remember. I don't know which copy you've got here, but I changed it. I actually, okay, you initially noted you might do a crash report. Why does my counsel say might do a crash report?
Mm-hmm. Why?
So I end up finding he ends up having a meeting with the law enforcement. With
The prosecutor?
No. The officer has a meeting with him, and he tells me he had a meeting with the officer. I'm like, what? When the? I'm like, when the fuck do you like? So anyway, but I'm like, when the fuck? And I don't know if he admitted to. So on the stand he's admitting to it.
What do you think?
Well, I don't know what
They're polled.
So here, is there tampering with evidence? Was there obstruction of justice? Was there duty of the officer of the citation? All these questions that, and then when you ask is so when did you tamper it, or when did you change it? How did you change it? Who did you tell that you changed it?
Was it after this trial?
Is this after the
judge?
communication? Is
Yeah.
this after the phone call from the Times reporter? Is this when you were getting calls from the sheriff's department? What? Yeah. So all these there's
Why would you
triers of fact. If when you destroy it, it implies so. There's here.
So they even admit that they changed it.
On the stand admits.
And then what?
What are the?
So what happened?
I end up getting convicted. The day trial.
Okay.
And here, look at all these inaudibles. That's even so. Anyway, we'll get into. And the verdict, and then
Was this in front of a jury?
yeah, and what's weird is the courtroom was full, but so then during sentencing, everybody's gone, or not every, but I mean, so the judge is there, the bailiff is there, the prosecutor's there, the arresting officer is there, me and my attorney. So when this was going on, my intellectual probably says, man, if I get convicted here, I made a promise to myself, I got. An official who does not comply with the law, meaning a judge, could lose his dub. But what I'm saying is, so we're actually in there, and I have the gut feeling that this judge is just gonna give a mock trial. But when a judge says it, it's a whole different emotion. I know I'm getting fucked, but when you tell me you're not gonna follow it, it just reaffirms there's an understanding that comes over you, whatever I gotta do now, I don't have to question.
It took you a lot to.
The permanently barring access, Trump versus Dawes, due process and everything. So everybody knew what was going on. Like the federal courts knew. Whoever accessed the bug issue report had information. So here's where it gets. So when I get convicted, so they sentenced me and stayed the case, stayed the sentence.
What did they sentence you to?
4 days in jail.
Okay, and then you didn't have to do that?
No. So they stayed the sentence pending appeal. So I needed counsel, right? Well, in the meantime, I'm appealing the ALS now. I didn't know that they infused. So people but now it creates a huge legal issue because now. But hold on. So I do a pro se appeal on the okay, and this is pro se. I'm going through all the legal issues, which by now we have a list of them, right? Huge list. They asked for an extension of time or whatever, and it was denied. And it fell like on a Friday. So on Friday, I go to the courthouse, or I try to get it, and they don't have it. I'm like, what do you mean? It's supposed to be filed or whatever. And so they take like a half an hour, and then it finally comes, right? So I go over it, and it's all like there's a lot of blank. And what's interesting is there was the part that sticks out about the right of counsel during the interrogation, okay? A couple days later, whatever, I still don't have my brief. It says she files it on this day. You see the timestamp of the dates of when it was placed, and they serve. Eventually, I get appointed Michael Putable, okay, for appellate counsel. And on the ALS, see transcripts, CV, this case, so this is the civil certified copy appeal order, and it was placed in Attorney Putable's, okay? So if you read the opinion, so here's the dismissal, the pro se. Oh, then the internal memo. So here's September 9th when I had. So here, if you see the assignment of error that he filed, remember that it was, my arrest was for OMVI?
Yeah.
And here he uses,
Zero.
and he's Rodin's attorney in his steroid case.
Oh God.
Here he is. So anyway, here. Appellate's argument or error presented upon appeal does not, this case, the argument of error is based upon TCRV 9909753. So that's the OMVI case. So on the OMVI appeal, they say the issues that you raise is the state case. So we were in the process of appealing, so he had to appeal that case. So if there were issues within this case that were raised that he refused to raise or didn't raise, we know that he was served in the OMVI case,
Okay.
ALS case.
All right. I think we've gotten
Here.
the intertwinement.
So but let's go a little. Courts have the inherent power to vacate a judgment based on fraud upon the court, even though such authority is not vested within rule or statute. So the municipal court actually could vacate this. When I say I filed the sunshine request, so Putable had filed, and there was, I said that there was no stay in the case. It wanted extension of time, saying that there's no stay. Well, there was a stay, so that misrepresented. Here, there are issues if he was the appointment of counsel, if there was conflicts of interest. Well, we'll see. But then, and what he raised, if it was properly, if it misrepresented the record. I'm barred from the federal court. The state court on the habeas or on the civil rights gets dismissed because you can't lose in a criminal case and then win civil rights violations. It has to be vacated in there. The appeal brief was filed. They're referring to the police law and all this during trial. You know what I mean? So I file for the Freedom of Information Act request. And that's when I get the police log, which contradicts everything.
On the
So
ticket?
yeah, so after years of trial is when
To get discovery?
after I'm barred. But here's where, so in the sunshine request, an affidavit by Dover Police Department did not prepare an Ohio crash report in connection with the incident leading up to the citation, the issuance of said citation. There is not now, nor has there ever been, a crash report pertaining to the incident leading to the foregoing citation. Crash report, hold on, 99352 is a true and correct copy of the original, Officer Brian Decker. So you say, wait a second. You have somebody swearing an affidavit of information that 352 doesn't exist. Well, where is he? So I have a citation sworn under falsification of perjury by the guy saying who's done it. So is this a factual correct statement? How can somebody who has no direct knowledge of if or may it could have been or that it was destroyed, why is he testifying or giving an affidavit that it doesn't? You following?
Wasn't he the officer?
No, that is I believe it was the chief of police for Dover.
Oh, who was testifying?
So here, now that raises a whole nother thing, because who's filing this with the court? So that's the judge's husband who oversaw the prosecution in my case.
All right.
So this would trigger, so wait a second. If Mr. Bengali has a citation under falsification of perjury, how are you, or why is there two documents under falsification of perjury? So that would raise issues that he would know information, not only him, but Dover Law Director. You follow him? Because he files this and he's overseeing the
I
prosecution.
know, it's a web, and the web keeps
So
getting
hold
woven
on. So
further out and further out and further out.
it would
How
implicate
far out are you going to go?
any question is this affidavit, can it be presented to the court? Would he have been in position to know if it was tampered with? File that with the court. You follow me? So then that would have put a law enforcement officer, wait a second, I have legal responsibility if there's falsification of perjury to report it. I have a duty to report.
They don't follow
Well,
their duty.
You know,
They're not going to
let me tell you, when people
on their, when they know the judge got their back,
well,
and the attorneys got their
that's
backs,
where it gets.
and they have
So
their
here's
fines.
where the police log that contradicts. So now we have the ending of the attorney-client relationship. So if Pewterball is my counsel, and the appeal is, when does it end? And does he tell me what I can further do? So were my files forwarded and all that kind of stuff. And then if he says, when did his official representation end? And when did he start representing the arresting officer? Now here, with the state withholding evidence and post are critical stages extending the right of counsel. So there's post-conviction relief and post-trial motions. There's two separate things. One has counsel apply, one doesn't. So if there's post-trial motions where we had discovered new evidence, does counsel attach? And was he the attorney of record? And now he's representing the officer of material that was withheld regarding the officer. And then we know that he's friends with, right. But it gets here, irregularities in proceedings. But there's one last slide. Can a prosecutor, should you have known the times and whatever, so we know you submitted a citation where the time is wrong, the particulars of the arrest are wrong, issues of refusing is wrong, issues of influence is wrong. We know the issues of the crash report and injury is wrong. So basically an entire citation that you submitted to a court. Here. Right to counsel on appeal encompasses the right to effective assistance of counsel and not mere nominal representatives of the appeals court if there's misconduct there somewhere. But here there was the internal memo where they were depriving trial transcripts. My appeal was on partial record. They refused to provide all the transcripts.
Why?
And then if you look at all of the inaudibles in the it's just in the closing statement, it's just loaded.
4 years by a system of buddy clubs of judges, law enforcement.
There's legal issue that my blocked access to the court impedes habeas corpus relief. Would have. So usually if there's a constitutional violation or whatever, appeal, but
Yeah,
so
you can't do it.
is that obstructing justice? So the blocked access to the federal courts, remember, and also of the excessive force and being forced off the road and the tampering.
Not misrepresented.